I pardon to mention, my lord. One promotion matter, ignoring my seniority, twice promotion have been made. So it was happened.
When it happened?
It happened last 3 months back. In respect of the same,
Last week of August.
My lord, this is fresh matter.
Which year?
2025.
25. Take all the memos. They will distribute them so that they will not cluster on one particular day, creating problem to the bench. Just distribute them. Yes.
Page 1, 2, 4. Page 2, 5 to 13.
Page 1, Your Lordship. Item number 2.
13, 15.
Item number 2, Your Lordship. I'm on DC.
There's a noting that no steps are for fresh issue.
Serial number 8. Serial number 8. First steps to be taken within 3 days, 3 working days, failing which appeal stands rejected peremptorily. 3 working days, 4 working days. Yes. Otherwise, it stands rejected. Yes.
Item number 2, Your Lordship.
15 to 22. Page 5, 23 to 26. Page 6, 27 to 30. Page 7, 31 to 36.
Item 36, my lord.
36.
I will take up next week, my lord.
Next week.
Some people you lost in my lord. Put a query to me, my lord. I have to answer that query.
Yeah.
I do not prepare on that.
Okay. There is a difference between a intervener and a party.
No, my lord. That the resolution was made. The recruitment tool is there, my lord.
Anyway, call this matter in first week of August 2020 at the request of. Next week we have difficulty. Calendar is heavily loaded. That's the reason.
Item 8, 37 to 41. Item 9, 42, 43.
my lord, in item 42, I have filed the counter as per my lord direction. And I am filing today that I am giving copy to them.
Just now I have received.
You go through and
Yes, my
come
lord.
back.
So I pray, my lord, on 24th,
24th, all
because the
documents
grant of renewal of agency, that nursing college is also remember.
When the admission process comes to an
30th September.
30th September.
Yes, my lord.
So we'll have it in the 3rd week of August.
First week plus
Second week of September.
My lord, this affidavit may be adopted for all the cases I have made.
As you fill a memo,
Yeah,
adopting all those things,
Yes, my lord.
then we will make an order to that.
Yes, madam. I have read the memos.
You have filed the memo
Yes.
also. Learned counsel, panel counsel appearing for the answering respondent submits. And the other
Council of Petitioners.
parties to the proceedings do not object that the pleadings filed in WP number
WP 10059 of 2025.
shall be the pleadings in associated matters.
Yes. I will file everything in the registry.
Same that's a page.
Item page 10, 44 to 45.
My lord, item 44, my lord, I pray for an adjournment. As my learned senior is in accommodation, my lord.
Out of station. In the 3rd week of August. At the request of.
My lord, 45.
But inform your other friends also.
Yes, ma'am.
They need not wait in the open court.
I have informed, my lord.
Well,
My lord, 45, last item.
45. Yes, brother.
Maybe actually to some other date, I am trying to contact him. Appellant. I am for the appellant.
Okay. Call this matter in the last week of August. At the request of the council appearing for the appellant. Finally.
Have you informed Mr. Mahanta? No, my lord. Please inform.
Yeah. You have to inform. Otherwise, he will be waiting here till 4 o'clock. And he will come to know that matter is adjourned when he stands up.
Rajiv, Rajiv Kumar, you should have taken it at the earliest. When you came to know that matter is on board and you are going to seek for an adjournment, you should have informed him at the earliest.
Do that now. Do that.
Item 1. Item 3,
Yes.
A single passover, I blame.
You want passover?
Passover.
This is a review petition. In fact, the main order, impugned order was passed by Justice Honorable Mrugang Sahu and then Justice Avindan Sinha. Now, since the bench is different, would you also like to hear the matter, or I'm ready with the matter? I can argue the matter.
If you want to, we'll hear. If you want same bench, we do not know when matter will come up.
I'm ready to argue the matter. Here, the basic question, I'll just give the short fact.
There is a registry notice there, man. Sir, notice has returned back. No, service of notice has not happened.
No, it's a fresh matter. It's a fresh matter.
Fresh matter?
Yes, my lord. Notice has not been issued as yet.
Yes.
I would just like to highlight the brief facts of this case, my lord. 3 different charge sheets were filed against this present opposite party, and 3 departmental proceedings were initiated against him.
Because the review, it has to go before the same judge.
Justice is no availability. I think the Chief Justice has all the documents compared to Honorable Justice S.K. Mishra. Since Justice Sahu was a part, the judge.
Technically speaking, actually, it should go before Honorable Justice.
There is a note also. My estimate brother is showing that to me.
Yes,
there is a note. Registry to post before the appropriate bench in terms of Honorable Chief Justice's note. It goes. Call after 2 weeks. 2 weeks, all right.
Yeah, absolutely fine, my lord.
2 weeks, okay. That's right. We need
Just my appearance may be noted.
Out of employment since 2015, Mila.
No, but we have no jurisdiction to.
No, I'm saying that
case paper at all.
whenever that bench, Honorable Mruganga Sahu, that bench will be constituted immediately. Maybe.
But therefore we can't do anything. We cannot turn the pages of this one also.
Justice S.K. Sahu, no base on. Special bench has.
Special bench is constituted. Shall we say post it? Yes, post the matter before the special bench in terms of Honorable Chief Justice's note dated. So
16/4.
Yes.
2025.
16/4/25.
Item C, my appearance kindly may be noted, my lord. My appearance may be noted, my lord.
उनकी खाली से ऊपर है जो कॉस्ट एक्चुअली लिखा है उसको आंसर लिख दे दीजिए ऑर्डर शीट
Item 6.
Yes, ma'am.
My lord, in this case, this is regarding grant of NOC for BSc nursing course, GNM nursing course. I have applied.
Make use of mic also.
Yes, ma'am.
Yes.
I have applied. There were some deficiencies. Deficiencies were rectified. Thereafter, they inspected and pointed out that the building has not been completed.
Similar matters we have posted to which date? 24. Similar matters.
Sir, have you received copy?
Yes.
No, just now he has given me copy.
Notice we have to order.
Just now copy I received me.
Issue notice. Learned AGA Mr. Mohanty appears for respond numbers.
1, 2, and
Respond number 1.
2 and
Sri Panel Council Sri appears for respond numbers 2 and 3. First up. Call this matter on 24/7.
Item 7.
When that company appeal, here we have to take instruction.
No, you have filed an IA for dispensing with filing of certified copy, for which it has been listed today under the heading for orders. It can be disposed of.
It can be allowed.
So on what ground do you have paid so? For dispensing with filing of certified copy.
Why that will be ready necessary?
Yes.
Office has to count the limitation period. How they will be able to do that? Suppose if the appeal is filed after the expiry of the limitation period, to compute limitation period, certain particulars on the back page of the certified copy would be available to the
Date of application, date of issuance and all.
Otherwise it will not be
The scan reporter has reported that it is in time.
in time.
So maybe
But it was distance in. You can say. Shall we dispense him? Application supported by an affidavit accompanies the appeal seeking a dispensation of production of the certified copy of the impugned order of the company court. First off, we are satisfied that such dispensation would not cause any injustice to anyone. And material particulars are available on the bank sheet, not available.
Till certified copies obtained. So, Mr. Mahathi, the prayer is till certified copies obtained. So, where is the certified copy? And why we should dispense with after 3 years?
Received, my lord, because at that point of time it was not.
No, it's not that you have prayed that till you obtain the certified copy. You produce a certified copy, you must have obtained in the meantime.
Dispense with for a period of 2 weeks, 2 more weeks. First off, the appellant to produce the certified copy in the meantime.
The certified very strange.
How they will say it is in time without seeing the certified copy? We do not understand.
We understand proceedings to be made again.
After production of the certified copy, registry to assert the limitation period and such other formalities based upon available data, based upon data availing on the pages of the certified copy. Okay. Otherwise, we will not know. I mean, going that period. Yes, next.
It is pointed out that 45 days delay in filing.
45 days delay. What is the explanation for that?
Well, the certified copy could not be obtained in time.
Notice has to go. Or it has, after notice it has come.
No, first time.
This is the first time.
Respondent.
First time.
First time.
Is there any private respondent?
No private respondent.
Only state is
State is.
We'll control that delay for 45 days. We extend that facility to you also. We have already extended.
It is reciprocal.
Appeal is filed after booking a short delay of so many days. First of an application supported by the affidavit seeking condonation thereof accompanies the.
No. You are Mr. Counsel. The office has pointed delay is 389 days.
No, my lord.
That has been pointed out.
No, my lord.
The date of judgment is 27/9/2023. It was presented on 19/11/2024.
No, my lord.
After deducting 30 days, it has been pointed out that delay is 389 days.
Appeal is filed on 13/12/2023, but the certified copy was
Because of that.
That only 36 days for that.
No, question arises whether an appeal filed without impugned order. There was impugned order.
Yes.
Certified copy or not. What is your case?
only
Order copy was produced.
order copy was produced, but not in certified
not
copy.
in certified.
Not in certified form.
The website copy has
I beg excuse.
But they have written. It accompanies the appeal memo. First off, registry has reported a delay of 300 odd days, which may not be correct, in as much as appeal was filed on
13/12/2023.
13/12/2023, along with the photostat copy of the impugned order.
website copy.
Website copy.
Yeah, downloaded.
Yes, a copy of the impugned order. First off, it has been long settled by the decisions of apex courts that where appeal is filed along with a copy of the impugned order, the appeal should be deemed to have been filed for the purpose of computation of limitation period, notwithstanding the non-production of certified copy of the impugned order. First, there is a plausible explanation for the short delay also. First, in the above circumstances, application having been favored, delay is controlled. Yes, what is the on merits?
My lord, the short point.
Yes.
It is a case of acceptance of application for changing of option. Either I will retain
Changing of
option change. Change of option.
option.
Change of option in retaining the either I will retain the existing scale or the revised scale.
That option was given to you.
Yes, my lord. So
Right.
according to the old circular, my application was accepted. So during the consideration of my earlier application, the Annexure 3 Finance Department brought out another office memorandum on 26/5/2012 while granting relaxation liberty, annex just page 26, paragraph 5.
Mr. Mahanti, we are hearing a writ appeal. You have to demonstrate before us that the judgment informed passed by the learned single judge is or worse.
My only thing
So,
is
please demonstrate from the informed judgment
yes,
which finding is bogus, deserving interference by this division bench.
my lord, at the time of deciding the my lord, my writ petition, the relaxation, my lord, the clarificatory circular under annexure and annexure 3, page 25 of the finance department has not been taken into account. Where under paragraph 5, my lord,
Employees who have not
Yes, ma'am.
changed their option.
as yet, in the above situation, but desire to have the benefit of different ORSP rules in terms of Finance Department Office Memorandum 22/9/99, will have to apply for change of option as per rules and submit the same to the authority concerned within 3 months from the date of issue of this office memorandum. Otherwise,
Not be considered.
Yes, ma'am. So, at the time of my lord, issuance of the office memorandum,
This office
Yes, my
memorandum,
lord.
already it was changed.
my application was under their consideration for acceptance.
We'll show that.
Yes, my lord. So that even if paragraph annexure 5, page 32
Of the writ petition.
of the writ petition, my lord.
It's not appended to the writ appeal.
No, the writ petition record must be
Petition,
on.
if it is a part of record,
Yes.
then it comes along. This
It's
continuation.
available in the website.
No, it is available.
Available.
If you don't have, you can go through that through Wacom.
Kindly see para 2.
Para to the impugned order.
No. Para 2 of annexure 5,
Yes, my lord.
that Roman, small Roman 2. The copy
Yes,
of
option form, pay fixation statement countersigned by DO Bhadrak under ORSP 85, 89, 98 has not been submitted. So if the financial loss, so these are the official discrepancies. So I have to comply these official discrepancies. Accordingly, my head of office, district education officer, as well as headmaster, they clarified the fact, annexure 6, page 34 and 35. 34, 35, also page 34, 35. So I have to sign the in proper format or any official discrepancies I have to comply with. But now my lord, in the meantime, when the revised circular came into force, without adhering to the my lord, the revised circular.
What annexure 6 says? Kindly see that.
My lord.
With reference to the subject cited above.
My lord, submission of original book, service book and other relevant documents of Sri Satpathy, assistant teacher, so-and-so high school, governments of Odisha, finance department order
For change of option.
22/9/99. Yes, my lord, this is a point.
Okay.
Yes,
Not that single judge treated this point.
yes, not analyzed, not interpreted.
No,
The only
this
single
document was not taken into consideration while delivering the judgment.
Annexure 3 is not taken into account. My lord, here, annexure 6, page 34, the department resolution 22/9/99 has been referred to, but it is a letter of 2013. By that time, annexure 3 has come into force on 26/5/2012. So they might have referred that instead of, my lord, the exercising your application for under the old rule, it has to be reappreciated as per annexure 3, finance department letter 26, dated 26/5/2012. Yes, ma'am. Simply
Mr. Mohanty,
procedural mistake.
there is not only process, there is mistake on your part also.
Sir.
When they sent that circular, you should have said, I have already made submission.
That has been answered in para 7.1 of the.
You take notice for admission. We are at the admission stage. He has made out a case for admission. But hearing we'll see that. The case is made out for admission in view of the contents of annexure A6, which prima facie vouchers that the appellant herein had submitted his option for. Learned AGA, Mr. Mohanty, on request and subs notice for the respondent.
All respondents.
First, on this matter in the third week of September. Okay.
Extra copy be served.
Please give copies.
Mr. Mahathi, your office also, this court, we have become paperless. What you'll do with the extra copies? When you are communicating to your, the state officials.
Download in the LMS.
Yes. So why you are asking for extra copies?
Employees.
So, best case, they will dump it in the AG's office. Extra copy don't hard copy.
If they're available on online,
LMS.
then there is no requirement. Policy, we did not know this. Every time we were telling advocates to give copies.
Item 10.
Respondent. We can understand. Where state is a party.
They are also filing this petition through, this through online.
Therefore, there is no need. Yes. What is this matter?
Government appeal. Government appeal to responding.
You are for respondent.
Respondent.
No notice is as it issued.
No notices are from, I filed contempt. In contempt.
Have you entered queue yet?
No.
Then we need not hear it. We hear.
Yes.
You have no locus. Yes.
But is the High Court appeal, wherein there is a limitation of 228 days minimum.
What's the explanation?
Because of this communication and in time filing, the same could not be done, though the department has been intimated.
Perhaps it appears you have filed this appeal only to avoid the order, the possible order in contempt.
No. I have got the merit.
What is on merit? Just shows.
No, was it preferred before getting notice in the contempt petition or after? After. Yes. The Postmaster General judgment of Supreme Court, each day's delay has to be explained. Simply taking a plea that this processing the file official case.
Government case, your lordship knows day in and out.
You don't know anything. You have to explain.
You pay some amount to the other side.
Whatever reasonable amount will be there, my lordship.
That's all. The AGA, Mr. Monty is this side. Issue notice both on limitation and on merits. First, can we condone it?
Yes,
subject to payment of some short amount.
Yes,
small amount.
Yes.
The intra-court appeal is filed after booking a short delay of 200. How many days? 220 days.
30 days.
30 days. First time. An application supported by the affidavit accompanies the appeal memo and it seeks condonation of the said delay. First time. Learned State Counsel Mr. Mohanty submits that in the official process, some delay has been brought in filing the appeal and there are some arguable points on merits. First one, with that as it went, denying rejecting application of the kind would result into rejection of the appeal itself. But first off, that may not be a desirable action at the hands of High Court. First off. Next paragraph. Learned counsel appearing for the private respondent, although initially resisted the application, now he is graciously agreeable to the allowing of said application, subject to the condition that whatever little prejudice his client has suffered because of the delay, some amount should be made to paid to his client. First, we agree with this submission. Next paragraph. In the above circumstances, application having been favored, delay is condoned, subject to the condition that the state shall pay ₹5,000 to the respondent employee within a period of 4 weeks, filling which not only filling with the application stands peremptorily rejected and as a consequence appeal as well.
Some less can be considered.
3,000.
Date may be, sir.
Otherwise, he will not do it. This amount may be recovered from the official who is responsible. No. We want to let them. It should not be public money. Your money, our money. Who is responsible for delay? He should be made to pay that. It is open to the appellants to recover this delayed amount from the official who is responsible for the bruiting of the. Okay.
Allowed to get that may not be reflected.
We are giving liberty. You may not.
You do not take any action at all. Yes.
One more prayer, my lord. Relating the appointment or realization.
Let us see. Let us see. Payment.
Yes, so let me fixed.
Yes, in the third week of September. Yes.
So they put payment of cost and filing receipt to the proof of source to the register.
Subject to payment of first and the proper filing of proof thereof in the registry. Okay.
Item 11.
May I please, your lordships?
Yeah.
Lordships, in the order dated 2nd of July 2025, your lordship decided the issue regarding regularization of those pharmacists who have worked more than 6 years in dint of the 2008
Date of absorption.
Yes, my lord. 6
Not
years.
appointment.
And these are the judgments, my lords. Your lordship's judgment, my lords. Same, only the distinction is a district.
Also. Apex Court also said same.
Yes, my lord. It's not, my lords have noted
Followed
that.
by judgment.
Only difference is that this petitioner, this person is from another district. Only.
So who is the other side counsel? Have you gone through this?
He himself argued that the subject matter of this appeal is substantially similar to the one in writ appeal number 1323 of 2023 between State of Odisha and others versus Chabindra Kumar Samal, heard and decided by us on 2nd July 2025. 2025. Next paragraph. In effect, we have held that the relevant date for consideration should be the date of absorption and not the date of regularization. Correct?
No, my lords. This issue is that they have a date of appointment and on 6 years pursuant to that, they are absorbed, regularized.
Under that 2019
and 2008 circular as well. So Lordship said Supreme Court decided they will be absorbed after 6 years, deemed provision is 4A of that 2019 circular, Lordships.
From the date of completion of 6 years.
Please, Lordships.
In view of the above, the similar matter needs to be treated similarly.
Para 5 of the judgment my lords have handed.
At paragraph 5 of the cognate judgment, not 5.
This is submission of the
submission. No, when we say that appeal is liable to be dismissed, nothing beyond that.
Yes.
As that is a delay of 1 year and 8 months, this post-COVID delay also may not be condemned. It's my request. Otherwise, it will set a precedent, Lordships.
Makes no difference. How delay matter, after some delay will be precedent. What you have written? In view of the above, this appeal is also dismissed. Dismissed. Yes.
It's said to be implemented as per the last para of the order, otherwise they will take some time for contempt.
Within what period you implement? The judgment of the learned Singh, in that what we have said.
7.6 para is that?
What we have said.
3 months. 3 months.
The impugned order of the learned single judge shall be given effect to within an outer limit of 3 months. Reckon from this date.
Get from the last. Mobilized.
Item 12.
Please, Your Lordship.
Yes, sister.
Your Lordship, last occasion, Your Lordship, I had filed a memo regarding the salary, the payment I have to receive only on salary. Nothing else I have.
Your voice is weak. Will not attribute weakness to the court's case, provided you raise your decibels.
Your voice is not audible.
Not audible.
May I please, Your Lordship? Your Lordship.
Grab that mic. It's for you only.
May I please, Your Lordship? Your Lordship, on last occasion, Your Lordship, I had filed a memo according Your Lordship's directions, Your Lordship, that the salary I have to receive, Your Lordship.
You have filed memo now?
Yes, Your Lordship. On last occasion, I have filed it, Your Lordship. That is only the salary. I have not taken into consideration any other remunerations, Your Lordship.
We can also please to see that memo flagged. Calculation, calculation
next page. Okay.
Is coming to 11,27,430, Your Lordship.
What is this matter about?
This was regarding a disciplinary proceeding was initiated against the petitioner, to which the Honorable High Court set aside and directed to give a de novo inquiry. Thereafter,
on what ground did he set aside?
It's a second round of litigation, Your Lordship. Yes, second round. In the second round of litigation, Your Lordship, I was exonerated from all my charges, and according to the statute, Your Lordship, section 48A, Your Lordship.
Claims as detailed in the calculation sheet for that period.
Yes.
For which you are you remain out of employment.
Yes, yes.
So after your reinstatement,
yes,
after this de novo inquiry, you are reinstated.
I was reinstated,
So
but
on that basis, you are claiming
no,
last period.
What the order they passed after de novo inquiry, they set aside then they said that the period which was I was not working, they said it to be as a treated as such that it will be no work pay.
No work, no pay.
No pay. But Your Lordship, as per the statute in section 48(1)(a), it says if you are exonerated from all the charges, then that period will not be treated. It will be treated as if you are on the work. Your pay.
So that is the basis to claim the entire wages and other financial benefits in this writ petition.
Writ petition. The writ petition was dismissed, for which I filed a...
It was dismissed.
Yes.
Why did learned single judge was not impressed by you?
In the writ petition.
Complete.
Yes, I was exonerated.
Just take us to that page.
Order by which you were exonerated.
Yes, Your Lordship. Section 14.
No, that order we want to see.
Yes. That is in the writ petition, Your Lordship.
Next order.
Annexure 14, Your Lordship. Annexure 14 and their page in the writ petition. 64, Your Lordship. Yes. In that, towards the end, he is exonerated from all the charges leveled against him. The period of his suspension connected thereto is treated as leave due and admissible. The dismissal period connected thereto is treated as without pay and allowances.
So this
last line is your one of attention.
Yes, Your Lordship.
Which is the statute which you read?
Yes, I have.
If an employee is exonerated from all charges, he cannot be precluded from pay and allowance. That is your contention.
Yes, Your Lordship.
So how it has been dealt by the learned single judge?
Single judge has not dealt with it, Your Lordship.
Totally not dealt with. That must be the only ground of
yes.
saying so.
Yes, Your
It was
Lordship.
not dealt with.
It was not dealt.
Please demonstrate from the improved judgment that it was not dealt with. That must be the sole ground to praise so. Yes. How it has been dealt with, you want to see.
That is the...
Next one.
Yes. A. The reasoning, Your Lordship.
Para?
That is from para 5. I have to go with till 13. In para 11 also.
The petitioner.
In 11 also, Your Lordship, the single judge has dealt with it.
Court's reasoning and analysis.
Yes.
Para IV. Is that IV point? Para 5.
Yes.
So, yes.
So, first time it has come.
No, Your Lordship. Your Lordship heard me.
Heard this matter?
Yes. And
who appears for the other side?
I am for the other side now.
Yes.
In fact, the Lordship hearing at a length to the parties. So, Lordship has directed on the ground of fixation. No, Lordship has directed.
Equity we will come. Yes. Equity is said to be a very variable. It is like Chancellor's.
Lordship's proposal was that way. In fact, for the dismissal period, what their law says, but they quote the Suspension Service Officers Regulation during the suspension period and the period the event is exonerated from all charges, is entitled for the benefit class as if he is in duty now.
You support the appellant
that is the law. That is
you are saying the legal position.
That is the service rules of SESCO.
Yes.
But now it has become the Tata Power has been implemented as a party.
Yes.
They have also adopted the same service rule.
Yes.
So it can be disposed of, allowing the appeal in favor of the appellant.
Yes. Your Lordship, that
without recording your concession.
No, your lordship has directed.
Last time we said to come out with some proposal.
Yes, Your Lordship.
That is the amount. Last occasion he has served a copy.
Because generally, apex court is of the opinion, the consistent views.
Yes, 11 lakh.
We have not completed. If you permit us, we will say something.
I'm sorry.
Then you complete yours and we will do ours. Apex court said, no work, no pay is the golden rule. But about 3-4 exceptions are enumerated, where rule itself says, then rule has to be followed. Otherwise, no fun in having the rule at all. That is one aspect. Even then, your friend is coming forward with some olive branch. You will do something then. What is that?
Your Lordship, only on salary, that is the period I have done, other than no remunerations, I have not said.
Subsistence allowance is paid to you.
That I have not, that is what I have, in the memo I have given.
Only differential has to be paid.
Yes.
In that, how much you will put?
11 lakhs, 27,000.
Mr. Mahanti, have you taken instruction from your client regarding correctness of the calculation sheet submitted by the learned counsel for the petitioner?
On that, Lord, I have taken instruction. Lord, since my Lord has proposed an equity, if it can be apportioned with the management, Lord. So, Lord, on my instruction, this Lord, it will be 50% of the amount they have suggested, Lord.
75%. 50%. We are thinking that instead of going into the right or wrong of the memo, calculation memo, we will not undertake that exercise. We will say some percentage of your arrears shall be foregone. Tell that percentage.
But my instruction is the amount calculation we have made on that 50%. But I'm willing and 11 lakhs amount. That is my instruction.
What do you say?
Your Lordship, if Your Lordship will kindly see the office order, which I have annexed in the memo, Your Lordship.
Office order?
Yes, with the memo I have...
Annexed 14?
No, Your Lordship.
Memo.
With the memo I have given on last occasion, I have filed that.
So this is a part of that memo at flag B.
Yes.
After that calculation sheet, office order, it's January 2017.
Office order.
Yes, Your Lordship. It is their calculation, Your Lordship, that I am eligible for.
No, we are not calculation at all.
Yes.
Now we are saying the on percentage basis, we are arguing before you.
Yes, Your Lordship.
You have to decide now. See, it's a public body. And if money is paid where person has not worked, maybe that you are prevented from working is another.
Your Lordship.
But some we always quote the scriptures say, Vinashakale samutpanne ardham tejita panditaha. This is what Gautama Sutra says. When everything is being lost, one who retains 50%, ardham in Sanskrit means 50% generally.
Yes. Whatever Your Lordship will recite, I am...
The object of rule is to reduce and minimize the discretion of the authorities, including the court. You have to follow the rule. If we follow the rule, you have to pay 100%. Because what my brother says, there is, rightly or wrongly, there is a rule. Unless you amend your rule, you are bound by the rule. It's your rule.
And there is an office order to this effect as to what would be the petitioner's entitlement. It has been worked out by the previous employer.
That makes the successor.
Detailed calculation. Have you seen that office order?
Yes,
It's a part of that memo.
Yes, Lord, that is the
6th January 2017.
Yes, Lord, that I have seen, but that is the calculate, that is the Lord, scale of pay, Lord. Lord, that has not calculated as my Lord and friend has calculated up to 11 lakhs.
No, they have
That is
calculated.
the mode of calculation.
Your predecessor has worked out it.
Yes, Lord.
Subsequently, it has come to the successor. Whatever predecessor does, the successor is bound by. Unless fraud, etc. is shown to us. That's not your case. So make it 75%. In fact, my brother feels we should follow the rule itself because rule says that way. Where is the discretion to us? You have not enumerated any exception to the rule.
This is the mode of calculation.
That's all right.
Please see that second column of that office order. Pay fixed oblique refixed.
Yes, Lord.
Date of fixation, thereof pay scale, grade pay, then remark.
Only from these, Lord, he has calculated and he has made it 11.
Yes, the employer himself admitted by this office order.
Yes, Lord.
Do you dispute that such calculation has not been done in terms of this office order?
Yes, Lord. Calculation
If it has been done in terms of officer, then what is the wrong done by the
employee?
And why should we reduce? If it has been calculated in terms of this refixation made by this office order for the period from 2002 till 2016.
That is the calculation made. But that is not the office order.
Sir, the second column, please see. Pay fixed completely refixed.
So that is the pay scale and these are the grade pay. All this not, these are the calculation sheet. This is not the office order making payment.
Anyway, question is, we are not on the calculation at all. We are not on the calculation. Court need not undertake calculation. The point is, you have already worked out.
Calculation sheet this is office order is there.
It is senior general manager, not somebody FDC, SDC, etc.
Retired with the last noting is he retired from service one. Now you will be paying this amount after so many years without any interest.
Then we will not reduce. Then we will not reduce. 2016, this I did not see. The question is, you have put him out from working. Can you complain?
Mr. Mahanti,
nothing like that.
You being a citizen council, you know what is the certification of when this principle of no work, no pay will come into role. You are responsible to keep somebody out of employment, and you cannot take a plea that no work, no pay principle will be made applicable.
Earlier occasion, my lord asked me whether you are arguing for the petitioner or not. Whether you are arguing for the
petitioner. Now, sir, because I was under the impression it happened in the recent past. My brother has pointed to this happened. In October 2016, she has retired. He has retired. That is nothing. You have to. This please be seated. This intra-court appeal seeks to call in question a learned single judge's order.
Let's on the quantum he had suggested, are you not suggesting? So on 75% of that, let's decide this.
75% with 9% interest. That exceeds this part. No, what my brother says. Two things. In fact, I wanted to do that way. Now my brother is pointing out. Well, there is a rule. Who are we to violate the rule? Let heavens fall down, follow the law. This is what Cicero said.
Earlier you are representing Sessu, you are the counsel for Sessu. So you know your client has admitted by passing an office order to the said effect.
Senior general manager.
They have that is the mode of had he been there in the similar work that would have seen similar.
That money you have to give because of your own rule. Your own rule. What is the object of rule? Rule is to reduce the discretion.
That is the reason why I have nothing to argue on that. That is the reason.
You calculate. If you are disputing such calculation, you calculate and pay with interest.
If you are disputing that her calculation sheet.
We have spent lots of time on this small matter.
Request part you lordship.
So you want cake and you want to have cake and eat it too.
No.
That's
only on your lordship proposition on equity, Lord, I have taken that instruction.
Equity comes when up in the absence of law. Is it not? That's Nelson equity, what the apex court said. Equity is justice, reverse law. But when there is law, how can we travel to equity at all? No, she will go with a hot button, saying that here is a rule and here are judges who do not want to follow the rule. What should happen to us? In one case, it may be loss to you, but that is not a loss because you occasioned it. Complete exoneration. This intra-court appeal by the employee seeks to call in question a learned single judge's order dated so and so, whereby entered in WP number so and so, whereby relief claimed by the employee has been denied. First, after service of notice, the respondents having entered appearance through their panel counsel oppose the appeal. First, next paragraph. Learned counsel for the appellant heavily banking upon a rule. Which is that rule?
48.1A.
48.2. You give that so submits that. An employee when comes out completely victorious after holding a disciplinary proceeding, what should happen to the period of suspension or of being outside the service so far as the remuneration is concerned, is regulated by law. And the law's rule says that the entire money which otherwise the employee would have drawn by way of salary and emoluments have to be paid. First, that being the position, learned single judge crossed the earth in denying relief to earth flight. First, next paragraph. Learned panel counsel appearing for the respondent opposes the appeal, contending that where the no work, the principle of no work, no pay is the golden rule, as has been held by the appellate court in a category of decisions, and therefore no amount is payable to the employee. First off, he also submits that some equities can be worked out by this court, and in that connection, some concession also can be shown from the side of respondents. First, next paragraph. Having heard the learned counsel for the parties and having perused the appeal papers, we are inclined to grant indulgence in the matter as under and for the following reasons. Number one, the employee had undergone a deep disciplinary inquiry and the proceedings ended in complete exoneration, almost on par with the honorable acquittal in a criminal side matter. First, it is because of the disciplinary proceedings the employee was suspended and was kept outside the work premises. First, if employee prevented from working, and subsequently the guilt is not proved, he will have an absolute right to claim all monetary benefits for the period during which he was out of employment or under suspension. First, that is the intent and content of the subject rule, which reads as under. Yes, next paragraph. Learned, yes.
Dictating also. the reviewing authority was under challenge before the
From
single bench.
14 to 21, all the orders were challenged.
They said office order, which
Yes.
you have filed along with the memo,
Yes, Your Lordship.
was also taken out of by the learned single judge.
Yes, yes. No,
That was
by Your Lordship's order.
That is office order.
No, the office order.
That note she has filed pursuant to our order,
Yes, Your Lordship.
not before that.
That is 27th October 2016. That order.
Which the note which the memo which I filed
Last
regarding.
moment. No, this is 5th January 2017. That is
5 January 2017.
Oh, that is 2016.
Reviewing order is on October 16th.
No, that input judgment बाहर करो तो read appeal rate return हुए
31/7/20. Implemented.
Para 10 and 11. Para 9, 10 and 11 for paragraphs. After the thorough review of the case, the committee concluded that although there were ample evidence of misconduct on the petitioner's part, the punishment to be overly severe.
Review.
Accordingly, Rule 51 of the SESCO now you have to zoom करो तो
My brother is pointing out that he was found guilty by the reviewing authority.
Your Lordship, of reviewing authority also there is under section 50 also, he cannot review after 6 months.
After 6 months, but
That
here
is-
it was
Within 6 months only.
No, Your Lordship.
During the DNO inquiry, they modified the disciplinary authority
Yeah.
order.
para 10, 11, you place it para 10 and 11. Para 10 and 11 of the input judgment.
Yes, Your Lordship. Yes. Yes, Your Lordship. That's section.
Place it.
According to Rule 51 of so now TPCODL Officer Service Rule regulation, the reviewing authority has the power to review the case within 6 months of the final order and pass appropriate orders.
Final order was passed on which date?
Final order was passed in this, Your Lordship, this is 14. That is,
Please tell the date.
yes, that is 29/2010.
And review was
Review was in
No.
20.
When the appellate authority passed the
Yes,
order,
yes.
thereafter,
Thereafter, it is 18. That is 1/8/2012.
2012.
Yes, Your Lordship.
It is at page 74 of the writ application, Lordship, you will find the review order on that.
Yes.
So was it within 6 months or thereafter?
Thereafter. That is 27/10/2016.
16.
Yes,
After
Your
4 years.
Yes, Your Lordship.
So you have challenged that order of the London single judge
Everything I have challenged in the
on that
petition.
ground.
All the orders, 14 appellate as well as 21.
He impugned order in this appeal.
Yes, Your Lordship.
review order also.
Your Lordship, in the single bench, in the writ
Asking
petition.
you.
Yes,
Is it your case that review authority could not have reviewed the order after the expiry of the limitation period?
Yes.
Did you take up challenge that order also?
Yes, Your Lordship. In the WA, Your Lordship, I have challenged the entire single bench order.
Not writ appeal.
Writ
In the
writ petition, yes, I have challenged.
and that ground was not taken out of by the London single judge.
Yes, Your Lord.
That is your ground.
Yes,
One of the grounds.
Yes, yes.
Which ground, please show us?
That is,
So that
this
in
is
the
the
petition?
fifth
Writ appeal. Which
writ
ground?
appeal.
Where you have taken such a ground?
Yes. That reviewers time bar.
And it was such a decision was taken by the reviewing authority after 4 years
Just
from the date of passing of order by the appellate authority.
yes, Your Lordship. 50, yes. In para D, that is 19.
Ground number
Page
D,
D, yes, sir.
page
Page 20,
20.
19 and 20, Your Lordship. D,
for that honorable signatures while passing him to the has failed to appreciate that
That aspect is not considered.
Oh, yes. The review petition filed on not to
He must not have done it.
yes.
That is not subsequent review. Prior to this, the petitioner has traveled twice this honorable court for this challenging that dismissal order earlier.
Sir, you didn't argue the appeal on merit, rather you considered to the
No, Lord.
grounds are before us.
Now,
that's
we
my-
notice that you are now showing.
No, that Lakshman kindly.
No, review was not time barred. Show us.
That reason being,
We do not know on that.
Well, review-
Your
review
rule says
standard.
review
Review
to be
standard.
within 6 months. Where is that? When the order of appellate authority was made, when the order of reviewing authority was made.
But the appellate authority.
1/8/2012.
But it was in 2012.
When did you review it?
But we reviewed it in 2016. Lord.
It could have taken another 20 years.
No, that is there. Lord. That is there.
That is the ground on which you are allowing the
Reason being, he has approached the Honorable High Court twice in doing.
Maybe
next motive.
And because of
Limitation.
tendency of the repetition here, my lord, and after dismissal, again the matter was remanded back to the appellate stage, where the de novo inquiry was conducted.
Correct. That order was made on 1/8/2012.
Yes, my lord.
Then you should have filed the review, you should have taken the review within 6
time.
Which time part? Therefore, madam is saying
that ground
is not taken
was not
note of
taken
by
of
the learned signature.
note of the unlearned signature.
It is urged in the petition, but not considered by the
No,
learned
that is there. That's what record.
learned counsel appearing for the employee rightly submits that the appellate order having been made on 1/8/2012, review order could not have been made beyond a period of 6 months in terms of regulation.
Regulation 50 Your Lordship.
Regulation 50,
51.
51,
50 within bracket 1.
In the
regulation 50 plus 1 of the subject regulations. First, this aspect having not been considered by the learned single judge, there is error apparent on the face of the record. And therefore, indulgence of this court is eminently warranted. First, next paragraph. The vehement submission of learned counsel that the review authority had found the employee guilty of reversing the original penalty order and the appellate order, and therefore that aspect needs to be given some discount is not impressive to us. First, a review filed and decided after the expiry of the limitation period, ordinarily is no review at all. First off, therefore, review order is otherwise also liable to be ignored from cognizance. First off. Next paragraph. There is force in the submission of learned counsel appearing for the employee that when he has been kept away from the service, the emoluments cannot be denied because he has emerged victorious in the disciplinary proceedings. First, Apex Court in a curtain of decisions has held that the emoluments payable to an employee are his property, and therefore non-payment of emoluments virtually amounts to the acquisition of property of the citizen, which violates Article 300 of the 300 capital A of the Constitution of India. First off, this aspect, a little we have discussed in another matter in writ appeal number 7. That other matter now, just mention that. Next paragraph. In the above circumstances, in the above circumstances, this appeal succeeds. The impugned order of the learned single judge is settled not. Petition appellant's WP number having been favored, the impugned order, but only that order alone, review order alone, because other orders are in your favor.
Yes.
Yes, Your Lordship.
The review or a writ of certiorari issues quashing the review order dated.
Yes. It is 27/10/2016, Your Lordship.
27/10/2016 is quashed. But as a consequence, a writ of mandamus issues to the respondents to pay to the appellant herein all back wages and consequential benefits till she demitted office, that is till 2016. What is that date?
The date is
October 2016.
that is from 5th to 2009 he joined.
Retirement.
Retirement is 2016. It's 2016.
There in the memo.
I'll just.
That memo, calculation memo, senior managing general manager, no? He has said that.
31/10/2016.
Yes, 31/10/2016. First of very reluctantly, we have denied interest on the amount that was otherwise payable to the employee, keeping in view the total circumstances. First of all, within what period you are going to pay this money?
Within 3 months.
3 months. Why 3 months for Tatas? The payment in terms of this order shall be made within an outer limit of 8 weeks, failing which the same shall carry interest at the rate of 2% per month.
My accurate is now 7%.
1% per mention. Per mention.
So far allowances are concerned, as you observed, but in the event he has not worked,
whatever
is not entitled.
No. That argument falls to the ground because you prevented him from working.
No, suppose some allowances are there, like house rent and other allowances.
Even those he would have been entitled.
No.
We do not know. We cannot be speculative in that.
He has prayed many things in the writ petition. Have you seen the prayer in the writ petition?
I've seen all these things.
Anyway, this is the general pattern of the order. The operative portion remains intact, and the linguistic form of the order will go little modification. Okay?
Obliged, Your Lordship.
Item 13.
Give that rule book.
Yes.
Yes. Thank you. Yes.
Covered by the
Yes.
Covered by
Covered Lordship's order, Millets. I'm passing to Lordship's order.
Okay. Both the sides unanimously submit that the subject matter.
Orders for one council covered. Consideration of applications, various applications, including the application for condonation of delay. On consent of the learned counsel for the parties, the matters since the subject matter of the present writ appeal is covered by the judgment of this court dated 8/7/2025 in writ appeal number 2629 of 2024 within the state of Orissa and another versus Vijay Kishore Nath and others, which is not disputed by the learned counsel for the
I'm for the respondent, sir.
Counsel for the parties. On being consented, the matter is taken up and disposed of in terms of the said.
May I make only one claim? Dismissed in view of the order.
Dismissed.
Yes.
The appeal stands dismissed. Then consequential order for implementation also states, since the state is the appellant, state appellant is directed to implement. This order within Contractual.
Grateful.
Within how much? 2 months.
Prescribed there only.
That order.
Item 14.
Grateful.
So for the respondents, not seems.
So, my lord,
The respondents.
other day, here the state is in intercourt appeal. On the other day, my learned friend has submitted certain Supreme Court decisions in respect of that Amit Mishra and all other matters, which is related to the pharmacist.
No, my lord, may I say something? It is Chittaranjan Meher. The ground on which they have cited, my lords, at last ground of the writ appeal, that same SLP.
That SLP was quoted there.
Yes,
SLP is dismissed.
Quoted there,
Yes, ma'am.
dismissed. But therein also, it has been well taken care of. The order in peculiar fact and circumstance, however, it shall not be treated as a precedent man. Apart from that, this present impugned order, which has been passed and assailed before this honorable court, it is all the way based upon the judgment of Viren Mitra Swami and others.
The first SLP 4253 minutes. There is a
Gitanjali.
minutes. May take up that Gajendra Pallai matter, minutes, for which I have all the pleadings, minutes. That is third on the tag, minutes. Gajendra Pallai minutes. The writ appeal 2902 of 2020.
This writ appeal, batch of writ appeal,
Yes,
are
sir.
covered by this order.
Yes, minutes. Not only once, twice, my lords. In the first round to Supreme Court, plus the Honorable Supreme Court said the question of law is kept open. In the second round, they traveled and I have handed over the judgment on which they are relying in their grounds of appeal in the writ appeal also. That has also been dismissed. Chittaranjan Meher matters.
It's on very firmly.
Yes, ma'am. Identical matters in one district is complied.
Do you dispute such submission made by the learned counsel for the private person?
It is
Going through the judgment, I will take some more time. But however,
So today it has been listed for under the heading for orders. Since there is a delay and you have filed an application for dispensing with filing of certificate copy. You dispute such submission or you need for further time to examine these orders.
I need further time.
So
Handed over the order. Well, last occasion I had handed on the order and everything.
to whom, Mr. Mahathir?
Yes, ma'am. Yes.
No, my lord, Dr. Chittaranjan Meher order was very well handed over to me. But
So you were heard also in the matter with my brother, other brother.
But my lord, so far this impugned order is concerned of the Honorable Single Judge. All the way this is based upon the Viren Mitra Swami and others, which has been carried out to the Honorable Apex Court by the state, my lord. That has also been disposed of in the meantime. And therein it is also covered that the question of law, so far this merit is concerned, it is kept open, my lord. The question of law is left open as the High Court has dismissed this matter on the question of delay and laches. For that, I will take further instruction, my lord. This is the order, my lord. I have.
Let's may submit.
The last
Let's at paragraph 10 of the impugned order of the learned single judge. It is at page 21 of the writ appeal, lordships. But it sums up everything. Identical case for Kandhamal implemented, lordships, in 2023. And in our case, they say that there is something open for them to appeal. Identical case, man. All paramedical workers, all were absorbed, all were regularized. Only the date of regulation was 2013. As per them, it was as per us 2004. Supreme Court has gone into that thing twice. In one case, they said the question of law is kept open. That is in Viren Mitra Swami, my lords. In that, they regularized 14 odd persons, my lords. Is their own annexure in the writ appeal.
How many persons?
14.
14%.
Yes, in one district, Kandhamal district, they regularize everybody. And subsequently, in their ground of rejecting my representation, they say that as because in Supreme Court, a few appeals are pending, which includes this 4253, Chittaranjan Meher, my lords, then we cannot regularize you.
4253 is Gitanjali.
Yes, Gitanjali. That is their ground in writ appeal.
Gitanjali.
Did you implement that particular policy in respect of 14% which
Yes, my lords.
that council is pointing out?
My lord, so
In
far
one
the
district.
MPHW is concerned. That we have to take in. So far the Gitanjali, they are all coming under the pharmacist.
And
No.
persons in other
They are in
Same category.
MPHW, multiple health worker, female and male. And all the way, kind of a glance to the impugned order of the Honorable Single Judge. This is all the way depends upon the relying upon the judgment of Viren Mitra Swami. That I have given the last order.
56. That formed the part of writ petition at page 56, annexure 8. This was, it was before this honorable court.
Whether is there any difference, qualitative difference between client of learned counsel and the persons, 14 persons of a particular district whom you have given already the benefit. What is the difference between these those 14% and these people?
Well, 14% that I have to take instructions.
Well, may I read one line from the single judge?
No, he said that he wants
they
to
are
take
all
instruction.
multiple health workers, Milan.
No, if you want time, we'll give you. The only thing is, you cannot be discriminatory based upon
I'm
district.
conscious, Milan. Even if 14% on the same standard, so this
Then
cannot be
that
unequal
to these
treatment.
people.
My lords, may I read the learned single judge order? One line at page 21 bottom, my lords, in their writ appeal paper book. My lords, Para 10, having heard the learned counsel appearing for the respective parties as well as on careful examination of the background facts of the present case as well as the materials on record, further taking into consideration the order passed by learned OAT in Biren Mitra Swai, case Supra so and so, which is confirmed by this court as well as the Honorable Apex Court. This court observed that the petitioner stand in an identical footing. In fact, the present petitioner as well as the above named Biren Mitra Swai were almost identically placed. The only difference is that they were posted in different districts of the state of Odisha. Since a view has already been taken by the tribunal, well, this is the finding, my lords.
So far,
This was carried in a appeal.
This is the single judge order which they are challenging, my lords.
carried in a writ appeal.
This is the increment writ appeal.
Apex Court, Milan.
No, this is the single judge order.
Let us. So far, the Biren Mitra Swai is concerned, Milan. That writ appeal, it has been disposed of on 5/10/2021 by the count of my lord 5/10/2021.
Writ appeal was fight. That is against this order.
Yes, ma'am.
The other order, which they have, that is various order.
Exactly, which is
Writ appeal number?
my lord.
That was a writ petition number. Writ petition
29224
of 20.
In that Swine's order, na?
Yes, ma'am.
That order by the learned single judge.
No, it is a division bench.
By division
bench. That is writ appeal number?
Writ petition number.
WPC number 29224 of 2020.
This matter you carried to the Apex Court.
Yes, ma'am.
In that, this is the matter relating to those 14 persons of that district.
That Biren Mitra.
14 persons.
Therein, my lord, that order it was disposed of so far the SLP is concerned. It was disposed of on 1/8/2022.
1/8/2022, keeping open the contention.
Exactly.
That's all. Now, tell us what is the contention. If they are similarly circumstanced, how can you discriminate on the basis of workplace? Read the 60.
My lord, for that purpose, I need instructions so far this 14%.
Whether they are equally placed.
Similarly situated with along with this person. I will not stand on the OM, my lord. My humble saying, let it be clarified. If at all, unequal treatment should not be there with your model state.
We are with you now. When do you want?
But in the record that construction that we specifically.
No, we'll call it next week. We'll remember everything. Everything will be available online. Na? We'll call this matter next week at the request of learned EGA, Mr. Mohanty. Post other connected matters also. Any other matter? All
matters are there,
yes.
All right. In the sub item.
Four of types of.
This is very well with the annex.
There is one
same one. All these matters will come.
One more writ appeal, my lords, mentioned 2889 of 2024.
Sorry, call
288
writ appeal number 2889 of
2024.
Along with
4.
Item 15.
You can't be discriminatory. You see that DP Joshi versus State of Madhya Pradesh, where Apex Court said, on the basis of residence or workplace, you cannot discriminate the persons. That is Article 16. The pith and substance of Article 16 is that one only. Place of birth or the residence, etc. You cannot discriminate the employees on that, except for rental purposes, allowances, etc. Not for this.
My lord, is it kept part-heard, my lord?
No, it completely. We do not know because we.
This has come for orders.
As because the hearing is
Anything that's let us.
Item 15.
grateful lordships. Item 15 is a delay of 56 days, Your Lordship.
56 days. Brother, can we condone the delay? Similar. Short delay of 56 days. Yes, what is the matter on merit?
The order dated 5/8/2024 passed by the Honorable Single Judge is under challenge, wherein the private respondent number 1 had approached this Honorable Court with a prayer to quash our order of promotion and to conduct a review DPC. Since he was not in the zone of consideration and we were given promotion on 27/2/2024.
You were given promotion on
27/2/2024.
DPC was held on which date?
The DPC was held on that is page 39. Uh, 22/24.
As on that date, he was not in the zone of consideration.
No, Your Lordship.
How do you say that?
Because page 37. The forest guards who were under the zone of consideration for promotion to the post of forester, annexure 4, page 37. This is the list of forest guards.
49 persons.
49 persons. The name of the petitioners. Appellant number 1 is page 37. All the appellants are in the said list. The respondent number 1 name doesn't appear here, Your Lordship.
Does not appear at all?
No, Your Lordship.
Has he said that this empanelment itself is wrong?
Yes, he had challenged and the Honorable Single Judge disposed of the writ application on the very first date. And thereby giving promotion to the private respondent from forest guard to forester. And
did you ask for time before the learned single?
No, we were not noticed.
Without notice?
Yes, and we have been reverted in the meantime.
You were not made party?
Yes, made parties, Your Lordship. Your Lordship may kindly see.
Without notice. What is the aggrieved parties are not heard?
Your Lordship, pursuant to the order of Honorable Single Judge, order has been acted upon.
No, direction was given to dispose of the representation.
Consideration.
And it was acted upon.
The Lordship see that
reconsideration.
Page 50.
For reconsideration, you will not be a necessary party at all. You will have opportunity at the stage of reconsideration.
I'm showing Your Lordship.
What is that order?
Let us see the operative
party para 7.
No.
That is page 50.
Page 50.
Learned Single Judge order.
Yes.
What is the operative portion of the order?
Page 50.
Para 7.
Considering the submissions made.
Annexer?
Annexer Miller's Annexer 8.
Annexer 7.
7. Page 47.
7. Page 48, our name appears. We are made parties.
Yes.
Page 48. The operative portion.
The single judge has not made effective order at all. It is an order to pass order on the reference.
Now Millard, thereafter gradation list has been prepared and they have been reverted. Now it is a separate cause of action which you have.
No, that gradation list was prepared.
Pursuant to order.
Where they asked to have their objection raised, there should be a draft gradation list. Thereafter, after inviting objection, it can be finalized.
Therefore, Millard, it's a separate cause of action to challenge in the writ.
Let's proceed. Learned single judge did not pass any order on merits. On the other hand, he says, without expecting any opinion on merits. Now, acting upon this order, they have taken some exertion. If they are aggrieved, it's a fresh cause of
only one thing, page 51, they have referred to implement the order of the Honorable Single Judge. They have given promotion to the private respondent number 1 and others.
Implementation means consideration of the order in terms of fresh cause of action.
Your Lordship may observe that.
Observe that only.
Because only one thing. And the review DPC was conducted basing on
that procedure.
My lord.
That is open to you to challenge.
That will
this by adding the other parties.
This intra-court appeal already calls in question a learned single judge's order dated whereby the writ petition, subject writ petition filed by the respondent having been favored. The direction. The following observations have been made at para 7. Yes, 7 you should reproduce. Next paragraph. Learned counsel for the appellant submits that the said order has been made behind their back in as much as no notice was issued to them, and therefore the order is in violation of principles of natural justice. First of all, he further submits that had a notice been given to them, the appellants, they would have shown that the respondent writ petitioner was not within the zone of consideration. As on 20 February 2024 when the DPC met, and also as on the date of promotion dated 27 February 2024. First one. Next paragraph. Learned counsel AGA Mr. Mohanty, on request appearing for the respondent, points out that the reading a perusal of para 7 of the impugned order shows that no order was made on merits of the candidates concerned, and what was ordered was only a direction to consider the representation. What is that?
To consider the case of the petitioner afresh by passing a speaking and
case of the respondent employee for promotion by passing appropriate orders. First of all, now appropriate orders having been passed, a new cause of action would accrue, and on that basis, the appellants can take up their legal battle. First, we're in agreement with this submission. First, next paragraph. In the above circumstances, this appeal being devoid of merits is liable to be disposed of, reserving liberty.
Not devoid of merit, liberty may be given.
Please have patience.
Dismissal, we are saying disposed of, reserving liberty to the appellants to work out their fresh cause of action elsewhere in accordance with law. First off, in that connection, all contentions are kept open.
My lords, I'm praying for an adjournment.
You are praying for adjournment?
My lords.
Why, sister?
My lords, I'm appearing on behalf of Mr. Panda, my lords.
Are you not happy with this bench?
My lords, Justice Mishra is concerned.
Otherwise, it's
Requisites you have to file for issuance of notice by Monday. In both the cases.
Right now, 24, I pray this matter to take up next week.
Which one? No, requisites have not. Are you appearing for the
24,
Not 24. It has been decided on the meeting for admission.
Yes.
You want adjournment?
Next week, I have not.
2011 matter.
Yes,
2011 matter. Can't give it. Next week you are doing?
Yes, madam.
Call next week, finally, at the request of Learned AG and the assurance that you would not seek any more adjournment. Okay. 2011 matter.
Yes, ma'am.
Yeah.
Where is the counsel for the petitioner? You are in item 24, you are counsel for petitioner.
No, that day they may bring the records called for by this.
Is there any order to the certificate?
Yes, ma'am. 3 orders are there.
The records are not come.
Nice. I only say that they will be
order dated.
When the order dated, first order is dated 9/12/2014.
14.
Yes, ma'am.
The yet to state is yet to comply this order.
No, I only pray that let them ask.
That is the date of order by which the state was directed to cause production of record.
That is 9/12/2014. First order 9/12/2014.
So far as the challenge to the aspect of promotion of the petitioner juniors is concerned, the learned counsel for the opposite party 2 and 3 would produce the records of the process of promotion as well as the disciplinary proceeding.
All right, when the entire whole Ramayana need not be read. Where is the order directing the production of the document?
That is, I only read out to your lordship, that is 9/12/2014.
You have not produced the document.
The file Jalajit personal file is with me.
So you would be able to produce it rather than when required by this court. It is already with you.
With you?
Yes.
Then show it to him also. You permit you to show that order because you want to bank upon those things.
No, my lord.
You don't want to bank upon those records.
The original file, my lord.
No, only to,
no, just show them.
My lord, lordship.
Anything
For inspection. Records of the process of promotion as well as disciplinary procedure.
They should look into that one. No one is there in that.
That was order for scrutiny of this court.
Yes, ma'am.
Required to.
Official Secrets Act is not applicable. You just permit him to look into your records.
Not only promotion, but also transfer.
Disciplinary proceedings also.
So many things is bringing, my lord. Transfer, promotion, proceeding, everything.
In one petition, everything has been.
That question is now over, my lord. Transfer matter, that is over. Now there is order, this order will indicate.
Anyway, next week we will do that.
Only now it is confined to the promotion.
Proceeding file as well as the personal file of the.
Only confined to promotion.
Yes.
Second matter may kindly taken up by Mr. My friend 6775020.
Which is that second?
Connected matter.
Connected matter.
2677.
Mr. Das?
677 of 2020.
Yes, just narrate the facts before we retrieve the file.
Facts very short. But the petitioner was appointed as the salary domain in the Justice of Denkanal in 1982.
No.
And salary domain in 1982. That post didn't have any promotional avenue. In 1998, the government of Odisha came out with a scheme of career advancement program. So there, with the completion 15 years, the persons, the cadre in which there is no promotion avenue, the employees will get particular skill, that advancement of skill.
Compensatory skill.
In lieu of promotion, 15, 25 and 30. So the petitioner
25
and 30.
And 30.
30. Three stages.
Correct.
So by 2012, the petitioner having completed 30 years had got the scale. And got the scale.
All the three scales.
All the three scales. And the sixth pay commission introduced the grade pay system. The grade pay system, he was already getting 2,200 as per the scale. As per the scale, he was getting 2,200 grade pay. So 2013, government came out with a modified scheme, modified career advancement scheme. Modified scheme. The modified scheme, the state government said that the persons who have already got, they will continue to get, and this is that the entry grade will be considered. Entry grade will be considered. That the preamble of that scheme, the entry grade will be considered. Thereafter, my lord, it is said that the scheme was changed for 10, 20, 30. So accordingly, the decisions...
which was 15, 25, 30.
It was 10, 20, 30. And 10, 20, 30. 10, 20, 30. And what will be the determinant factor? Determines for the entry grade. Sorry, madam.
Why before the division bench?
Judicial employee, it has to be before division bench. Judicial employee. So what happened, my lord? The integrate, as per the integrate, the petitioner automatically got 2,400, getting grade for 2,200, 2,400, then 2,800, then it was 4,200. She retired in 2018. My lord, DCS sent the pension papers to Accountant General. Accountant General objected to it. So that no, the integrate will be that his initial scale, salary on his scale, that will be treated, so you will not be entitled to 4,200.
In the preamble.
No, not in preamble. Preamble, he treated the preamble. He's saying that integrate means whatever, when he joined service, what is the integrate? So the original service. So accordingly, the grade pay will be analyzed or fixed accordingly. So based on that, he objected. Well, decisions clarified that and sent letter to the Accountant General. No, this is the system. Based on this, actually, he is entitled to get. And thereafter again,
he is not agreeable.
Thereafter again, he repeated the same thing. Same repeated.
Who appears for the respondent?
My learned friend, Mr. Acharya, senior advocate, appearing for Accountant General.
And that in all the three matters, my lord.
And this has also filed counter.
Sir, since pleadings are complete,
yes.
It needs a detailed hearing.
Yes.
You file date chart and note of submission with citations.
I've prepared the date chart, not note of submission. Prepared the date chart, but not
rejoinder and
everything is
on record. So better.
I'll date chart I have prepared, but the note of submission I'll prepare actually next week.
No decision of this court on this point.
Yes,
there are judges. So then you produce all those things along with your notes.
Next week,
next week we have difficulty. Second week of August week.
My appearance may be noted in all the three conducted matters, my lord. For the Accountant General.
To give this slip.
Associate.
Yes, my associate is there, he will get this.
Give the slip to the court.
In the main case, there's an interim order.
In all cases. In all cases.
Order obtaining shall continue till next date of hearing.
Item 27.
My lord. Lordship order dated 19/6/2025. 16/6/2025. Leave has accorded.
19/6, not 16/6.
19/6, sorry. 19/6.
Yes.
He was accorded, my lords. I will soft copy on my lord's friend, my lord. Lords, it will be converted to government criminal appeal.
That is, it needs to be converted into government
criminal
appeal. First time. While order dated 19/6/2025, leave having been granted, come on, we had said at that time. Next paragraph. Learned government advocate submits and we agree that the petition shall be converted into government criminal appeal on a normative basis. Within what period? Anything who register to accomplish the task. They vary from state high court to high court. Another high court.
Wait, please, Your Honor. What's the second matter is the lead matter in this matter?
Second matter is the lead matter.
Yes, ma'am.
Give that second matter. Yes, just make statement.
Yes, there is a delay of around 64 days in filing this.
Who is the...
Mr. Das had appeared on the last date.
Any objections are filed?
No objections have been filed.
We'll conduct the delay, brother.
So far as pro forma respondents are concerned, I am entering appearance on behalf of pro forma respondent. I have no objection to the.
But on contesting respondent? Not here.
Last occasion, Mr. Samir Kumar Das was present.
He was present.
Yes.
No objections are filed.
No objections.
The intercourt appeal is moved with a delay of so many days. Application submitted by the academic chief takes resolution. First time. No objections are filed to the application till date. First time. The delay is short and the explanation offered is found plausible. First, in view of the above. application is allowed and delay is done.
There is one writ appeal, 1868 of 2024, that is there in the cause list, but that matter is not listed. It only says with 1868 of 2024. That matter may also be listed.
List writ appeal number sites along with these.
My lord. In writ appeal number 1.
In the file note, it is mentioned.
The record is also available. There is High Court. Writ appeal 1868/2024. It is on board.
That writ appeal has been filed by another set of candidates challenging the same judgment.
But their names are not reflected.
Yes, ma'am. Yes. Therefore, that matter may be listed.
Call this matter.
My lord, this is the writ appeal.
1868 of 2024 in the usual way along with this matter. Okay.
This is the writ appeal 1868 by 2024.
In the first matter. Continue. Only first matter.
Only
I am appearing only in the first matter for the respondent.
Well, in the first week of September.
Yes.
And for the appellant, my lord.
Yes.
Appellant is present and respondent also present, my lord.
Order dated 2nd July 2024, passed by Honorable Single Judge, in which, my lord, that Honorable Single Judge has held that the revision petition under Section 15B of the Orissa Survey and Settlement Act is maintainable against the order passed in the mutation proceeding, my lord.
That are those proceedings are instituted under which section?
The proceeding first that mutation was done under Rule 17, Rule 18 of the Orissa Mutation Manual, and appeal provision is provided under Section 92.
Therefore, learned single judge has said go before the revisional authority. What is the scope of revision?
Revision, my lord, if in a settlement proceeding, my lord, major settlement proceeding, if the ROR is published under Section 12 of Survey Settlement Act, my lord, record of right, my lord. ROR means record of right. It's published, final publication was done under Section 12, my lord. Then only the revision is maintainable within 1 year from the date of publication. And the suit is maintainable within 3 years in the civil court for correction of the ROR. You will also note that
Survey Settlement Act.
Yes, in quasi-judicial proceeding, the Limitation Act is not applicable if unless it is specifically provided, my lord. You will also kindly come to Section 12 of the Orissa Survey Settlement Act, 1958, my lord.
Section 12.
12, my lord.
Yes.
Preliminary publication.
Criminal publication.
12B, my lord. 12B. 12B.
12B.
12B. Final publication of record of rights.
Yes.
When all such objections in the appeals are disposed of, the assistant settlement officer shall finally frame the record of rights, incorporating all such alterations as may be necessary to give effect to the orders passed on such objections and appeals, and such cause it to be finally published in the prescribed manner, and such publication shall be conclusive.
That order passed under 12B was challenged before the learned single judge.
No, it was no, my lord. I challenge, my lord. I purchased the land from one Pratap Chandra Patro. I filed mutation proceeding. I purchased in 1996. I filed a mutation proceeding. Mutation proceeding is allowed in my favor. Record of right was prepared in my name in a mutation proceeding. Without challenging that order in mutation proceeding, the respondent did not challenge that.
There is a provision of appeal.
Appeal. He filed a petition under section 15B of the Register Survey Settlements Act.
15B.
15B. You also before the Additional Commissioner's Survey and Settlement.
Board of Revenue.
You will also kindly come to 15B.
Given by Board of Revenue.
Yes. Board of Revenue may in any case direct of its own motion, my lord, that is A is not applicable. B. On application made within 1 year from the date of final publication under section 12B, the revision of record of rights or any portion thereof, whether within the said period of 1 year or thereafter, but not so as to affect any order passed by the civil court under section 42. Here, record of right was published in the year 1984-85, my lord, in the name of Pratap Chandra Patra, my lord. Then I purchased, my lord, in 1996. In mutation proceeding, the Tahsildar allowed my petition and recorded the land. My lord, that
when
record
you purchased?
96, my lord. I purchased it on 25 1996.
24?
5 1996.
Pursuant to that, your names were entries were made in the record of right.
Record of right.
When that was made?
That was made in the proceeding number, mutation proceeding case number, my lord, 563 of 1996 allowed on 19/8/1996.
1996. Your name, sir, entered in the record of rights in respect of that property. Then what happened?
Then this respondent 4 filed that revision under section 15B of Service Settlement Act in the year 2011, my lord. SY 138 of 2011.
So it is time barred according
time barred, and I submitted that this he has no jurisdiction to pass the order under section 15B, my lord. The honorable single judge held, my lord, you also can come to the relevant portion. Para 6, my lord, at page 37.
Yeah.
So far as the submission of the petition, that the additional commissioner has no jurisdiction to entertain the revision petition order section 15B in the matter of correction of record of through mutation without publication of record of rights has no merit for consideration. It is for the reason that the language of section 15 is clear to include the correction of record of rights through mutation.
Why learned judge says it is condonable? Delay is condonable.
No, that is not condonable. 1B is not.
And Limitation Act provisions are not, section 5 are not
applicable in quasi judicial proceeding, my lord. The number of
they can take up suit.
Yes.
At the most.
Yes.
Yes, to be wrong. No provision for condonation or delay.
No, there is no provision.
This question is considered by any of the judges of this court?
No,
it is a very old act, 1958 Act.
58 Act.
Whether this question is arising in the court or for the first time.
My lord, your lordship, I will come to section 34.
34.
Limitation of applications.
Yes. Subject to provision next following section, every appeal presented application made after the period of limitation shall be dismissed through limitation has not been set up.
This is like
Defects.
section
Only
three.
in the case of appeal.
Like
not-
section 3 of the Limitation
Yes.
Act it is. Not only act is not applicable.
Not applicable.
On the other hand, it intends that appeal should be dismissed. Yes. But this does not include revision.
Revision does not include revision.
Then 34 is not applicable.
Not applicable. No other provision is there in that. And Honorable Supreme Court in number of decisions said that section the Limitation Act is not applicable in the before the Judicial authority unless not specifically
not a court.
it has been prescribed in the statute.
The issue note. I have heard learned counsel appearing for the appellant. First off, he draws our attention to the text of section 53 of Odisha Survey and Settlement Act 1958 to contend that the proceedings are time bound and therefore the learned judge grossly erred in condoning delay in the absence of enabling provision. First off, he seeks to draw support from the text of section 34 of the Act also. First, matter merits deeper consideration. First, issue emergent notice. Learned AGA Shripad request accepts notice for the official respondents. Private respondent is there?
Yes.
One,
Yes,
two,
my lord.
one, 2, and 3.
Only four.
No, 4 is private.
No,
Private.
4 is private.
You will take notice to.
Emergent notice to private respondent, returable within. But
The operation of the
in the circumstances of the case, impugned order of the learned single shall stand suspended till next date of hearing. Let us see after they come what they will say.
Obliged.
No decision of this court whether delay can be
No,
condoned.
no.
Oh. Any other?
For condonation of delay, no separate application is needed.
Application is not needed. See, application condoning delay on application is one thing, but even for that, there has to be power to condone. Unless you have got power to condone, you cannot condone delay. That's the policy of the state.
That is inherent, perhaps.
Very inherent. No, inherent power cannot be used for condoning. For example, the inherent power of the revenue.
If sufficient cause is shown, my lord.
No, question is power. If there is power, then grounds for exercising power is one thing. Power to condone is one thing. Grounds to exercise that power is another. Ground may be that what we choose say. But initial power is not there. And Limitation Act is not applicable. Because the 72 Supreme Court, the Limitation Act applies only to the courts. Unless provisions of the Act are borrowed by this Act itself.
Express provision.
Yes, express provision.
Item 34.
Savitri Provision versus this.
Yes, poor peers. Nobody for state.
Yes, my lord.
But it is matter about.
My lord, this is an appeal where the learned single judge, the elaborate discussion is there, but the error which we have challenged before your lordship, my lord, when the rule is specific on the point how to regularize the service, how to make the contractual appointments regular to the regular establishment, rule has been framed.
That is not
Learned single judge says that before, anterior to the rule, they are continuing. So the rule will operate prospectively. Rule will not stand on the way. And they will be, they have been given direction for regularization. Bypassing the rule.
How rules are structured? Do they say Will any indication in the rules that
Yes, my lord.
earlier appointments are not?
72 contractual posts were abolished and 72 regular posts were created. And all these contractual employees, it is open for them to contest along with the open market pool. But these London single judge says that they have been continuing for so long.
How long they were continuing?
Right from 2006. 2006.
2006. All. 2000 rules came into force when?
2016.
2016.
So by that time, 10-year rule was operating. Even in your government order, government resolution, which you have quoted in another matter, there it provided for regularization after the expiry of very 5 years, 6 years. 6 years. Then these people have put in 10 years.
10 years.
That was contractual appointment scheme in 2023, which has been abolished. So there, what the government was doing for many of these regular vacancies, they were conducting this.
And that rule was not assailed.
No, rule need not be assailed.
Now that rule is no more in vogue. That 2013 rule.
16 rule.
No. In 2013 there was a scheme that has been revoked. That is
2020. It's a specific rule for these 76 posts.
These very specific posts only.
Specific rule.
No. Not specific.
Let us,
my lord.
They were working for 10 years.
Yes, my lord.
Before coming into force that rules.
Yes.
And others you have already granted benefit.
No.
Was there any?
We have to get
that is other employment, on the other department, other posts.
Correct.
These posts are postgraduate teachers, my lord. PGT.
No, Mr. Panda. See, after march of law from Dharwad daily wages to Uma Devi and ML Kesari, if they have gained entry in a non-objectionable way to the service, and if they have
continuously irregular, there are irregular employment and other are illegal. That is the difference.
This is not question of to decide that whether entry level is illegal or not, tainted or not. You cannot bank upon the rules that have come into force subsequently.
Our only anxiety, my lord, if they will be considered by Honorable Court's order, my lord, Article 14 giving field, level playing field for the open market candidates, that will be encroached.
But what to do? They have allowed them to work since 2006.
They are free to come, my lord, contest with the...
But already a similar set of people have been put on regular basis. You have other day, you brought to our notice government resolution of 2008, government resolution of 2013 in respect of other set of employees working in health sector.
Yes.
But why to deny?
Pharmacy. Yes. It's a group D, group post, group C post, group D, group C post.
But they have been working. Is there any complaint against them?
No, nothing.
No complaint.
That is not borne out on record.
Not borne out.
That is
no. What indicates that these rules are applicable even to the cases of these things? Is there any indication?
Yes. Saying that specific for these, for regularizing these employees posts, the rules has been framed. For regularizing these contractual posts were abolished, 72 regular posts were created, and rule framed for
72 posts created when?
2006, my lord.
Then they have been working in the regular post only.
OPSC was, it was stipulated that OPSC will conduct the entire selection procedure.
When it was stipulated?
2016, my lord.
But by that time they were already in.
They were already in, but by virtue of tribunal's order, they were continuing, my lord.
They were already in service. And by the time Uma Devi came, already they had put in...
Uma Devi has got a stipulation that litigious employment.
No, that's all right. But Kesari, what to ML Kesari? Because that gives a pinhole now.
Here there is no irregularity in the appointment also.
That's what, therefore I asked whether entry at any point, is there any
Working interview is my lord mere formality, working interview. Advertisement on working interview, they were, and the post is specifically stipulated contractual. The language is employed contractual.
It's a kind of exploitation.
In a socialistic pattern of society, state cannot do that.
And series of judgment came, therefore the rule was framed for regularization.
You apply those rules to the rest of the people, if there are any, not to these people. They have already shed their blood, their sweat on the floor of your premises. They cannot be put to prejudice that way.
Well, they can contest along with other candidates.
Nothing like that. Because we have the state is in intra-court appeal laying a challenge to the learned single judge's order dated so and so, whereby respondent employees writ petition number so and so came to be allowed with a direction to regularize their services.
Yes, sir.
Regularize their services. With effect from
2006.
How it can be 2006?
Right.
With effect from the day you complete 10 years.
Right, sir. That is what the single judge has said.
It has to be that way. Otherwise,
Yes.
then it requires a modification.
But
First of all, learned state counsel appearing for the appellant vehemently submits that there is a set of 2023 rules, 16 rules, which are promulgated to cover cases of the kind, and therefore, ignoring these rules, the learned single judge would not have granted relief to the employees in question. First of all, he also pleads the ratio of Uma Devi to alter the good judgment of the learned single judge. He has taken a single judge.
And another
Kesari also, ML Kesari.
not in the case. It is Nihal Singh.
Next.
It's also a number of years of this book.
Learned counsel on the notice appearing for the respondent employee, please be seated. Mr. Pandit, vehemently resist the appeal, making submission in justification of the impugned order of the learned single judge and the reasons on which it has been structured. First of all, they submit that pursuant to government orders of the resolutions of 2008 and 2013, in almost unmatchable circumstances, the services of employees have been granted regularization, and therefore that benefit cannot be denied to the respondents on the principle of parity and equality. First of all, they also submit that the rules having been promulgated only in the way in 2016, the employees having gained entry way back in 2006, the question of invoking the rules for denying benefit which otherwise accrue to them in the regularization jurisprudence will be prejudicial to interest of their clients, and therefore it cannot be. First of all, they also invoked your Uma Devi and Uma Devi, ML Kesari and Nihal Singh, which learned single judge located. First, having heard the learned counsel for the party and having perused the appeal papers, we define indulgence in the matter, broadly agreeing with the reasoning of the learned single judge and the contentions of senior advocates appearing for the employees. Next paragraph. For the following reasons. Number one, the learned advocates appearing for the employees are right in telling us that government resolutions dated 2008 followed by 2013 provided for regularization of contract employees of the kind in other departments, and therefore, as a matter of policy, these respondent employees are entitled to be regularized in service, which the learned single judge does not. We agree with this. Next paragraph. Ours being the socialist pattern of state constitutionally ordained, the directive principles of state policy provide for betterment of service conditions of the working class. First of all, this aspect of the matter is also unanimously matter also appears inanimate from the perusal of the impugned judgment of the learned single judge. First up. Above, next paragraph. Lastly, learned single judge has considered the ratio in Uma Devi, followed by ML Kesari, followed by Nihal Singh, which we are in total agreement with. First up, in the fitness of in the above circumstances, this appeal being devoid of merits is liable to be rejected, and accordingly it is from a costly reports having been made easy. Yes, put the citations in that one. People from the learned single judgment structure.
Can you not say it's up a time limit?
No, put me policy. ML Kesari is not cited.
No, ML Kesari has not been appointed here.
You should have cited ML Kesari also.
ML Kesari is an irregular appointment. Here we are
Is a regular
appointment. That is what we say.
No. Otherwise, the question of regularization.
The question
of regularization arises.
Umadevi said that one time you can regularize the service. ML Kesari said even if the appointment is irregular,
then also.
In this case, you are it is an open advertisement application.
One more sentence.
Reservation of
we are told at the bar and that the entry of the respondent employees to the public service was preceded by some type of selection.
Yes.
Selection. And therefore, we are of the considered view that the entry level is not polluted legally or factually. First.
Can you also fix up a time limit? Because now
the appellants are directed to give effect to the impugned judgment of the learned single judge within an outer limit of 3 months. 3 months. Okay. Delay will be viewed seriously.
Item 34, 35.
This case, I was allowed to take alternative notice on OP number 3. My learned friend, I have served the copy.
Today, in appearing for the OP number 3, I have filed my book log.
Yes.
So I pray also kindly 1 week time granted to file the reply in the counter.
Learned counsel.
Respondent number 3. Respondent number 3,
yes,
not OP.
Sri so enters appearance and files Wakalatnama on behalf of respondent number 3. First off, registry to all the name in the published. Mr. Panda appears for.
Yes.
You are already there. Is already there. First off. Counsel for the respondent number 3 seeks a short accommodation to file his pleadings, if any. First off, call this matter in the second week of August 2025. Yes.
Interim order to continue.
Interim order is there?
Yes, sir.
Then we will call it in September. Well, interim order is already there. Interim call this matter in the first week of September 2025. First, interim order obtaining shall continue till the next date of April.
My lord, I pray one thing. My lord, this order was under challenge before the regional director.
You want to argue? Or you want time? If you are arguing very well, we will take
take the time on September. So I will also take the August.
Earlier date. Yes. Last week of August.
Last week of August.
Item 30.
In 2025 has handed the sealed cover, and the same is opened by the court officer on our instruction. We will go through the report. Thereafter, if there is anything to be disclosed to you, we'll disclose it also.
That's
We'll put
not
this matter.
I am. That's not required, my lord. Your lordship, I have immense faith on that, your lordship.
Suppose if we want to hold something against you, then it has to be shown to you so that we will have your say over the matter. There is nothing hidden in that.
Yes, yes, sir. Absolutely, my lord.
We are thinking to send it for fresh evaluation. Would you agree to?
Previous, my lord, I have just brought to a dossier.
Because of the year 2023.
My lord.
Any vacancies?
Huge vacancies are available.
Vacancies are there.
Only I will appear for interview, viva. If I will qualify, then I will go for the viva. That's
no problem. Is other day just I went through myself and my other brother Sahusa went through the answer sheets actually, which you have also produced along with that. No? You had obtained under RTI. RTI. Now we have received the report also. Report will create more problems, maybe to us and to you also, than solving it. Therefore, just we are thinking, if this paper is sent for evaluation at the hands of some, we are just thinking, we are not yet made up our mind. We are just asking, what do you say? Mr. Panda? No. The report we had called for other experts.
Independent experts.
Not experts. The RG has given the experts the opinion that he has narrated a particular way, in a particular way he has narrated.
So for this.
Yes, 45. 45. They are marked 42. 45 is the qualifying mark.
So even if these scoring and correction are taken note of and total, it comes to 45.
45. Because that 12 marks has...
No, it's not 12. That appears to be manipulated. So means it appears to be not 12. Yes. It appears to be 10.
10, my lord. And yes. On the first page, it has given 9. That is the whole problem. Where there is 12, that is been given 9. Question number 4, my lord.
But so, adding this 3, if it is 9, then one more then here, person 9, see that way. That's what we will see subsequently. Voting for us, I mean, this week is also the subsequently somebody, the person who evaluated this paper would have
We have seen the report. We have seen the report very meticulously. We have turned the pages of your answer sheet also. Things are not that simple. Truth needs to be ascertained. If things happen like this, we are not ascribing anything to your client. We are not attributing anything to your client. The figure of 9 marks is made 12 marks. And that 3 tilts the balance.
Yes.
Because you are at 42, according to them. You say you are 45. That is on the basis of the entry made in the first page of the answer sheet, which you have read to us other day. Brother Sahu was also. Other day you said that. If that is asserted, because ink is different, handwriting is different.
Yes.
Therefore, we will direct a forensic examination of this document. Let report come. Mr. Panda, we think of doing like this.
Yes,
because
sir.
it's not a happy thing to happen, even the judicial system itself.
Yes, exactly.
We are not saying anything against anybody.
Anybody, my lord.
Anybody. Let
Judicial-
report come.
Yes, yes.
Thereafter, if necessary,
Absolutely.
we will order some very
Absolutely.
in-house inquiry, something like
Yes,
that.
sir.
Absolutely.
Yeah.
Yeah, in our order dated, which is that? 3/7/2025, we had said as under. Next one. Pursuant to said order, the learned ASC, additional standing counsel appearing for the respondents has secured the original answer sheet of the petitioner along with the report of the Registrar General of this court report dated 14/7/2025, prepared by the Registrar General. First up, we have very carefully perused the answer sheet by turning its pages and meticulously applied our mind to the entries of values as against answers given by the evaluator. First up, we are of the prima facie opinion that there is some interpolation of the values, and more particularly at page 1 of the answer sheet. First up, doubts arise in our mind as to the ink and the author of the apparent alterations being different from the original ones. First up, truth needs to be ascertained. Since the matter pertains to appointment of a judicial officer in the lower judiciary. First up, next part. In the above circumstance, we also put our proposal to learned counsel appearing for the parties, to learned ASC and also learned AGA, Mr. Panda. First up, they got on with our proposal. First up, in the above circumstances, we direct for the forensic examination of the original answer script with the following questions. Number 1, whether there is any interpolation in the pages of answer sheets. Second, whether original script and interpolated script are of the same author. Next paragraph, whether the ink and pen used by the original evaluator are different from those relatable to the subject interpolations. Question mark. It is open to the forensic expert to see other aspects of the matter as well. First up, registry to take next paragraph. Registry to take all steps to implement this order. Seal cover documents are returned to the ASC, and he acknowledges receipt of the same. Give that.
Fix a time frame.
The entire exercise should be accomplished within a period of 4 weeks. 6 weeks. Yeah, within a period of within an outer limit of 8 weeks. 8 weeks. List this matter before this very bench after the forensic report is forensic examination report is obtained. Come for further consideration.
Immediately after.
Immediately after. Yes.
Item 40.
I will plead your lordship.
Yes, sir.
My lord, here the petitioner has filed this application challenging the action of the university in not declaring the result of his BTech examination.
You have written the examination?
Yes, Lord, I have returned the examination.
They are not announcing the result now?
They are not announcing the result.
Why?
In fact, in one subject practical, I could not attend the 5th semester practical of a particular subject matter in that particular year. And ultimately, I appeared in the said practical in the final year, that is 2019. So it was due on 17-18. By that time, I was ill, so I could not appear in the practical.
You are the briefing counsel?
My lord, he is my lord the college.
College.
And my learned senior is appearing for the university, BPUT.
Yes, sir. He says that I have written the examination, announced the result. What's your no?
That is not the fact. Fact is not this 4-year course, not the degree course. He has to complete within that period, or there else not the
time-bound course.
Time-bound. Thereafter, not the 3 years period as allowed for 4 students. Not. Fact remains not his claim to be that he has
only 6 years.
7 years. Not
7 years.
Yes.
3 years course. Another 3 years.
4 years course.
4 years course.
Then 3 years. Additional years.
Yes. That university to accommodate the student, poor student, and to appear. But here, Lord, the fact is that Lord, he's failed in this 17-18. But his claim that he has appeared examination and he's succeeded, that is that Millard aberment. But the fact remains, Millard, he has never uploaded the college never uploaded the same in the university management system, nor even a register for the said
examination take place in whose premises?
College premises.
And the records are loaded to whom? Your university.
Yes, that is a portal, Millard. He has to upload it in the university management system portal.
Correct, but when he said the college is affiliated to you.
Yes, correct.
The affiliated college, you have full control over them.
Correct.
What you have done?
Lord, we have said, Lord, we have replied them that it is not, if you are not uploaded in the particular time-bound period.
Now, suppose if he has written.
Yes.
In time.
Yes.
But there is delay in uploading.
No,
it's not
uploading. Not yet.
How can he be made responsible for that?
Sir,
what is his fault?
Students. Lord, kindly see, Lord, the date of filing the writ application.
May you also allow
2024. And the issue of 21.
No, that's all right. It's a question of very the limitation question.
I'm not saying the limitation, Lord. The fact one kindly similar to my counter.
We are asking pointed question to you.
Yes.
Has he written the concerned examination?
Lord, so far as the university is concerned, he has not appeared in the examination.
He has not appeared, or it's your case is that what he though appears but is not loaded.
That is the start in the college.
What do you say, college? Did he appear in the examination? He appeared.
31 mark is secured, madam.
Yes, sir. But why did you not upload it to the university?
22 March 2021, institution issued one letter plus PD post to the deputy regarding updation of practical mark 5th semester subject design.
No, you can really answer what university is saying. You have not uploaded. What is your answer to that? University is saying he has not written the examination at all. How you will know whether
he has not registered? He has not registered. He has to register in the university to appear in the examination.
My registration number, my lord, paragraph of the counter, my lord, 150110527.
He was registered.
My lord.
He was registered. Was he registered?
My lord. Registration university.
Registration number is
150110527. 05276.
15011 5276.
0505276.
Annexer 1/3 mailer, my counter mailer.
So lakhs of people appear in the examination.
Already one letter issued.
It's a government engineering college.
That's what poor thing.
But there is a government engineering college. It is around.
So number will be whose? 15011505276. That is the registration number. That registration number was given by whom? By the university.
BPUT. Mr. Satpathy, you represent BPUT.
Yes. Regarding the letter dated 22 March 2021, college issued one letter. No, speed post, my lord.
To the university.
Yes.
Saying that he has appeared for the examination.
Yes, my lord. Representative upload the 31 mark.
Have you received the account?
Yes, I have already filed the reply and previous date, Lord, I have filed the reply before
He
your
replied
lordship.
that, my lord, he is not received on 2021, he is only received on 2024 letter. As annexer 3 of the lead person.
21 letter is not commented upon by you.
No,
They have not.
Not.
On my representation, the college physically communicated the mark to the BPUT University. They did not upload it
21.
in the year 2021.
21 itself.
Yes, my lord. That is very much. That is very much within that 7 years.
College has filed an affidavit
saying that he has taken exam.
Your lordship, I can come to annexure 2 of my writ application, my lord. Annexure 2 is the by a writ application, my lord. This is the communication of the college to the university. And at page 11, my lord, the mark. And it has been duly communicated to the university in time. That is very much within that stipulated 7 years, which my lord senior is arguing, my lord. That within time period also it was communicated, of course, on the representation.
What is your comment on this letter dated 18/3/2021, where they have said in so many words that registration number is so and so.
Yes.
He has secured 31 marks in DME.
Yes.
Practically in 5th examination after de-evaluation, requesting you to kindly forward the marks manually for uploading.
Yes.
What is your comment on this in your readings?
So far as the registration is concerned, Lord.
They have given the number also.
Yes, yes. Not kindly.
Can we suggest one thing to him?
Yes, ma'am.
Instead of we levying cost in rupees 1 lakh or 2 lakhs, best way is advise your university to do justice to the student. Registration certificate is there. He has written the examination. Valuation took place. And 31 marks he has secured. What is his fault? Assuming that fault is with the college, why he should suffer? Number one.
Yes.
What action you have taken pursuant to the letter of the college?
We have filed the reply that is.
You don't refer to this letter at all. You have referred to 2024 letter.
Yes, no, this.
But what happened to these 3 years?
Mr. Satpathy.
I understand. I understand.
No, your VC has to be here.
Please come to Annexure A/3. That letter dated 22/3/2021. In proof of sending the same by speed post to you,
yes,
has been appended to the counter affidavit filed by the college.
Yes,
that their dispatch register.
Yes, that is there.
With proof, this postal receipt.
Yes,
have been appended to their counter.
Yes.
What is your answer?
Still, you say that we have not received.
No. Suppose I am not properly
you are not troubling us. You are troubling him.
No, Lord, I am not troubling anyone.
Mr. Satpathy, we are telling you, this is a bad case. A student is suffering. You have to be kind to the student. What's in Marathawada University versus so and so? What Supreme Court said? The university should conduct itself as the patriarch of the students, mother of the students. It is the way that you conduct the business in the university. We'll direct the personal presence of your registrar and vice chancellor here. Instead of that, do something and render this matter infructuous.
7 days time.
Render it infructuous.
Next week I will take
not instruction. You render this petition infructuous.
Just to but because to save the I'm not against the student. I only student how to make regular.
What action you have taken against the college?
Not yet. Not. That's true, Milord.
It is affiliated.
Milord, that's true, Milord. What your lordship suggesting is absolutely correct. I am not standing on the way.
You have conference with your registrar.
Yes.
And show that court has shown its red eyes.
That is what my...
And let them do that.
Yes.
They render this petition infructuous in your own interest.
Yes.
Otherwise, it will be front page news tomorrow. I tell you. You cannot do that to the student. You should understand the sensibility. Why these suicides and other things happen? Because of this attitude.
Exactly. Okay, we'll take street. I'll come back with Milord concrete professor.
Call this matter having heard for some time is reluctantly adjourned to the call this. Which is that? Some date to give.
What date maybe?
So that learned panel concerned Mr. Satpathy shall confer with the university authorities and come out with some positive response.
Under this 2017, so we put to 28?
28. For the same batch. This is too much. This is too much.
One request on dated
for constitution.
So one judgment, my lord, on other day 20 June 2025, passed the order, my lord. Honorable Court opposite party presenting one book, Fundamental Right by Professor Ishwar Bhatt to the Library of Orissa High Court. It is not available in the
book is not available.
No,
some other book. Professor Ishwar Bhatt was a Vice Chancellor of Karnataka Law University, the Calcutta Juridical Science Institute of Juridical Science. Great author. Some of the apex court judgments refer to his writing. Therefore, we said that book is not available now. Which book it is? Ishwar Fundamental Rights or Fundamental Rights? All right, you give is another book, law relating to NGOs. He is an author of that book also. Give that book. It's available in library. Yes.
Item 41.
Nobody is giving book in the Muslim law. Kindly.
No, we have ordered in two matters. Hanafi's outline
from Muslim law is required in the library. I have seen.
No, two we have ordered. We will order other matters of this one.
Yes,
we'll do that.
Mullah's principle of Muslim law.
Mullah's Faizi's outlines of Mumdan law instead of right now. Learned Council expresses inability to secure Professor Ishwar Bhatt's book, Fundamental Right, and therefore is permitted to present two books of Faizi's outlines of Mumdan law to Advocates Association Library within at earliest.
Item 41.
Yes.
Well, this is the matter. The petitioner retired from service in January 23 as a driver in the Judicial Service, my lord, and District Judge Cuttack. Annexure 3, my lord, kindly see. Annexure 3, page 11. Well, his period 11/10/2004 till his appointment on regular basis, that is on 1/7/2008, shall be counted as qualifying service for the purpose of pension in view of Rule 14 of OCS Pension Rule 1992. My lord, in 2018, this order was passed. Thereafter, my lord, he approached this Honorable Court and this Honorable Court directed to consider the case. Now they have rejected the Finance Department, which is impugned before your Lordship, Annexure 7, page 16, rejected the claim that you have come to the regular establishment on 1/7/2008. So you are not...
One second, sister. This is 16/8/95 to?
That is to 2004. But 2004 is the initial appointment because Annexure 1, you are selected on a contractual post, page 9. 95 is an ad hoc 89-44 days basis. So I am also not claiming that period. I am only claiming from Annexure 1, page 9. That is my first appointment on contractual basis.
Annexure 1, page 9.
My lord.
What does it say?
My lord, Dushmant Kumar Dhar, son of such and such, district Cuttack, is appointed as a driver for a period of 1 year or till 31/3/2005. Whichever.
We'll have it in September. Pleadings are complete. There are many other older matters. That's the
Pension matter, if your lordship, my
that's
lord.
true. Therefore,
Let it be before your lordship, my lord.
He has retired.
Blessing.
He has retired in
23.
23.
My lord, not getting a single file, lordship hard last
What's the
time.
pension?
I am very hopeful today that your lordship will hear.
This is service.
I also thought that.
So you filed the written notes.
My lord, I have filed the rejoinder and also, my lord,
So
similar
because of
matter.
that only we are advising you to file a data and note of system.
This is
So that it can be taken up in the month of August.
yes, my lord. This is the
Second
judgment.
week of August, we
My lord.
put this matter the second week of August, with the understanding that both the sides will argue the matter on merits. Take this. But in the meanwhile, you file a
Written note and my lord.
written. In the meanwhile, written notes to be filed by both the sides. Okay.
Item 43.
Gender is